And now over to Trump legal world, where special counsel Jack Smith is delivering his sharpest rebuke yet against Judge Aileen Cannon in the classified docs case. In a filing just late last night, Smith saying Judge Cannon had ordered briefings based on, quote, fundamentally flawed understandings of the case that has, they call it, no basis in law or in fact. Now, in plain English, what does that mean? Special counsel Smith is telling Judge Aileen Cannon that she has no idea what she is talking about. So what's this all about? Well, Judge Cannon requested jury instructions from both sides. And no, you didn't miss anything. The trial has not started. And no, they haven't even picked the jury. I mean, the trial date itself is written in pencil, not ink. But Jack Smith wants the judge to reject Trump's claim that he cannot be prosecuted because he transformed somehow classified documents into private property under what's called the Presidential Records Act. Now, last month, the judge seemed to signal that she thought that defense was absurd. But then, here's the confusing part for Jack Smith's team, she asked for jury instructions that would say the opposite. So now the big question is, where do we go from here? Well, National Security Attorney Brad Moss is here with me at the Magic Wall. And as I understand it, Brad, we have got three options here, three doors. So what is behind door number one? What happens if Judge Cannon does not agree with Special Counsel Smith?
So this is sort of the nightmare scenario for the government. If Judge Cannon disagrees with how Jack Smith outlined everything in his filing and sends this to a jury with that jury instruction, it's basically an open shut case in Donald Trump's favor. His lawyers could sit there, play Candy Crush on their phones the entire time because the way the jury instruction is currently set out, it would not allow for the government to win. That's why Jack Smith outlines this in the beginning of his filing, saying it is vitally important that the court promptly decide whether the unstated legal premise, this idea about the Presidential Records Act, underlying the recent orders, does, in the court's view, represent a correct formulation of law. They're saying, this is what Jack Smith's saying, is you've got it all wrong. You certainly don't understand how this Presidential Records Act works with respect to the Espionage Act. Trump's whole legal theory is garbage. If you send this to a jury like this, jeopardy will have attached. We won't be able to appeal a directed verdict in his favor, and we can't even proceed to trial at that point.
So she's got to decide as a matter of law that this defense cannot be available. She's trying to punt to the jurors to say, hey, what do you guys think about an issue she's supposed to decide? All right, well, how about door number two? Because now the question is, if the judge does change the jury instructions, what does that enable Jack Smith to do?
So this is sort of the reverse. This is Donald Trump's nightmare. This is what the government wants to see. This is the way the Espionage Act cases always proceed, is it's simply an issue of, was there unauthorized possession? Did you have the records? And did you fail to return them when confronted about it? That's the essence of their case. And this is what he outlines, Jack Smith's team outlines in the filing, that the question of whether the Presidential Records Act has any impact on the element of unauthorized possession under Section 793E, which is the Espionage Act provision, does not turn on any evidentiary issue. This is basically the DOJ saying to Judge Cannon, this is a strict question of law. It's not a question for the jury. You're the judge. You have to decide this now in the pretrial motions. Do you agree with Donald Trump? If you do, go ahead, rule in his favor, we'll appeal to the 11th Circuit. But if you don't, you've got to reject his motion, you got to throw out this jury instruction, and we proceed to trial with standard jury instructions in an Espionage Act case.
So under door number two, or behind it, the case could still move forward compared to
Absolutely.
if they choose the jury instruction that Trump would want. This case could be DOA.
Correct. If
Wow.
if it's door number one, it may well not have a case. The thing is over.
How about door number three? I hate to even click it. Let's see what's going on with door number three. The question is, if Cannon sticks to her initial points, what are the special counsel's options then? You mentioned the appeal.
Yeah, so this is where I think we're likely headed to, is it's a question of, does she simply dismiss it through the pretrial motion as a matter of law? Or does she say, I'm going to try to keep with these jury instructions, but I'm going to tell you now in advance of going to trial? That's why the government was very clear here. The government must have the opportunity to consider appellate review before jeopardy attaches. They have to be able to bring this to the 11th Circuit now, if she's going to go this way, before they start their case. Because once they start their case, double jeopardy attaches, and if there's a directed verdict in Donald Trump's favor, they have no appellate options. That's why they're saying, pick what you're going to do. At this point, just decide what you want to do as a matter of law. We'll go to the 11th Circuit if we need to do so.
So reminding people that the jurors are called fact finders, right? They decide issues of fact, but the court decides the legal issues. And so if she does not rule on this motion to dismiss, then they would not be able to go to the 11th Circuit Court of Appeals, and then they get to go to a trial, and then it could be all bad?
So this is where this is really interesting. If she tries to punt this now, they're going to seek what's called a writ of mandamus. It's a very extraordinary option. It's very rarely granted.
Don't speak Latin to me tonight. Tell me what it means.
Writ of mandamus basically means it's extraordinary relief. It's telling an appellate court, the district court's messing up. They're doing something, it's abuse of discretion, completely misunderstanding the law. You need to come in and intervene now. That is what they will likely have to do if she tries to continue to punt this to the jury. They'll seek what's called that writ of mandamus, tell the 11th Circuit, you've got to set her straight right now.
You know, setting her straight, some people are talking about that might mean considering whether she should remain on the case. That's going to be a pretty lofty ambition.
Well, I'll be waiting to see. I don't necessarily know if they're going to go that route,
Yeah.
but that would be part of the discussion, no doubt.
Well, we'll see. The gloves seem to be off so far. Bradley Moss, thank you so much.